Thank you for coming here today to hear our panelists to what they have to say about the impact of courts in securitization. In essence, an investment is a contractual agreement between a buyer and a seller, and in securitizations especially, relies on the transaction documents because of the passive nature of the special purpose vehicles. And the only way that a securitization can work properly is if every party in the transaction acts accordingly. As the market is evolving, the long-held doctrines we have relied on, they are being challenged, and the new legal guidelines are being implemented. So when this framework gets challenged, it impacts every industry participants, ranging from issuers, servicers, investors, and of course, the lawyers. So in this panel, we're going to discuss some of these topics that are affecting the market currently. And throughout our panel discussion, I would like the panelists and the audience to focus on three things. What happened? Why does it matter to us? And what are the implications on the industry going forward? So as an introduction, I'm Florence Chan, the head of ABS research at PGIM Fixed Income. I have no legal background, but I've been working closely with my counsel, Jake, and on some of the recent cases in ABS. And my panelists, please introduce yourselves.
Hi, I'm Chris D'Angelo, a partner with Cat & Muchin in New York.
I'm Mark Harris. I'm a finance partner with ALSTON & Bird in the Dallas office.
I'm Eve Kaplan. I'm also not a lawyer, and I work in corporate trust at U.S. Bank.
I'm Peter Partee. I'm a partner with HUNTON Andrews KURTH in the bankruptcy department in New York.
Hi, I'm Howard SIDMAN. I'm a partner in the financial markets practice at Jones Day.
So we're going to start with you, Chris. We know that the Supreme Court has in front of them cases challenging the constitutionality of both the CFPB and the FHFA. Can you discuss how these cases came about and what the court's potential rulings could mean for the industry?
Sure. I mean, the two agencies that are at issue here are the Consumer Financial Protection Bureau and the Federal Housing Finance Agency, which are probably two of the most important agencies this industry has to deal with. And they're both being challenged in separate actions, basically over the same issue, which is whether their governance systems are constitutionally adequate as a separation of powers matter. I'll go through them very, very quickly. The one that's actually being heard by the Supreme Court is the Celia Law case, which is Celia Law apparently is like a debt relief counseling law firm, and they received a civil investigation demand, I think it's called, from the I'm not a litigator, but from the CFPB, and they resisted it on the basis of that the CFPB is unconstitutionally structured. That is, specifically, it has a single director who is removable only for cause by the president, unlike, say, the Secretary of the Treasury, who serves, at the pleasure of the president. The other thing is that the CFPB also gets independent funding. It's not through the appropriations process. So they resisted the civil investigation request on the basis of this governance issue, and this has ended up at the Supreme Court. At the moment, let me go through some of the amicus briefs, because let me actually go to the point that Florence asked. What were the potential rulings for this? Potential rulings are basically nothing. They could say, no, it is constitutionally structured, or there's some problem, and the problem could end up with, I suppose, this particular discovery request being vacated. And if that were to happen, you start to think, if that were true for that, why wouldn't that be true for other things? Like you start looking at, say, the qualified mortgage rule, or you start looking at a bunch of things. You go, if this one thing turns out to be vacated because of this constitutional defect, what does that mean for everything else the CFPB has done? The other case is the Federal Housing Finance Agency case, and that case actually involves a lot more money. This is shareholders of Fannie and Freddie challenging the so-called net worth sweep, the feature that basically prevents Fannie and Freddie from recapitalizing themselves, and figures prominently into the idea of getting Fannie and Freddie out of federal conservatorship. So if the shareholders, once again, it's basically the same issue with the same result. If that particular, if the net worth sweep were to be vacated, which is what the plaintiffs have asked for, once again, everything else the Federal Housing Finance Agency has done becomes presumably subject to challenge on that same basis. The counter-argument that even, it could be okay, it is constitutional, or you could simply sever this particular thing about the director from the rest of the statutes and have it so that the director, in fact, could be removed by the president for any reason at any time. And that also has become an interesting thing, because we hear about this, we hear a lot of times about courts like striking down provisions and statutes, but if you actually look at the law on that, it's not very clear that that's the case, and this is what the plaintiffs are arguing. Like, if you were to remove this part of the statute, either the CFPB statute or the FHFA statute, then you're left with a law that Congress, in fact, did not pass, and the president, in fact, did not sign. So there's quite a bit to these cases. So we'll see what happens. I mean, I think the Structured Finance Association did not send in an amicus brief on these. Mortgage Bankers Association did send an amicus brief in, and not surprisingly, it says, we don't care so much about what the answer is, just don't rock the boat. You know, don't, you know, again, these are two of the most prominent agencies, most important agencies that we deal with. So we'll see what happens.
But I think in these cases, right, they're raised by private parties?
Yes, it's one of the curiosities of these cases. I'll take the Celia Law case actually as a good example of that. It's in the scope of things, it's a picayune little matter. I mean, it's not of great moment. So you wonder how do these people get to challenge, you know, bring a separation of powers argument on the basis of trying to resist this complaint? And the answer is the Supreme Court has sort of made it that way. At one point, the same principle, it's called the Appointments Clause under the Constitution, was raised by several congressmen. Several congressmen sued to try to make the same argument on the Federal Reserve Board. Same thing. Some of the Federal Reserve Board members are appointed by regional banks, not by the president. So members of Congress went after the Federal Reserve Board. This was actually D.C. Circuit Court said, you can't do that. You don't have any standing to do that. So if those of you who are lawyers, if you remember in law school, there was probably half a class one day on justiciability and the political question doctrine. This is that. Interestingly, the branches, at least the president and the Congress can't really sue each other in any meaningful way to try to resolve these cases. So oddly, these private plaintiffs get to raise these, you know, momentous constitutional questions.
Thank you, Chris. Yep. So next, we're going to move on to Peter, the bankruptcy remoteness of special purpose vehicles. So towards the end of last year or 2018?
It was November 2018.
November 2018, the court dismissed an involuntary petition filed against a bankruptcy remote special purpose entity, the Taberna CDO.
Correct.
Can you tell us what happened in that case?
Sure. I think, you know, when I go back over it now, over a year later, I think Taberna is probably the single most important court ruling on bankruptcy remoteness for securitization structures in a long time. And not so much for the very technical basis of one of the grounds that it dismissed the involuntary petition on, but on the more policy basis that it articulated. Basically, Taberna involved a CDO. It was a CDO that was in default, and it had issued multiple tranches of non-recourse debt of varying priorities. And the senior-most tranche had been accumulated by a particular entity who wanted to proceed based on the default to liquidate the collateral in the CDO. And it wanted to do so principally because doing so right then in the way that they proposed would maximize the return to the seniors, but at the expense of the more junior tranches of debt. That's the most general way to put it. Predictably, the juniors refused to vote for this outside of bankruptcy when the seniors solicited everybody's vote to liquidate the collateral. And so the senior tranche responded by trying to achieve the result it could not achieve outside of bankruptcy through an involuntary bankruptcy filing against the CDO entity. There were multiple technical problems with its ability to do so. First and foremost was they were holding secured debt and that it was non-recourse debt. And the bankruptcy code says you have to be an unsecured creditor to be a petitioning creditor in connection with an involuntary petition. And so they had a huge technical problem, and they tried to solve it by manufacturing an unsecured claim, by releasing their right to the collateral to the extent necessary to have an unsecured claim. And it was clear that they were trying to circumvent the provisions of the indenture that provided the rules for the liquidation of the collateral and the rules for how to amend those liquidation rules. They couldn't get what they wanted outside of bankruptcy, so they went into bankruptcy and said, hey, we're going to propose a plan. That plan is going to provide for the immediate liquidation of the collateral, and the unsecured, the junior creditors are out of the money, so they don't even get to vote on that plan, and the court ought to just push it right through. The court was having none of this. The court basically said, you have these technical defects with your claim, and that alone is the basis on which I can dismiss this case. And that's all great for bankruptcy lawyers to debate endlessly about whether a non-recourse claim constitutes a claim for purposes of filing an involuntary petition. That's the boring part of the case. It's technical and it's irrelevant for this group. What's really relevant is the alternative basis that the court relied upon to dismiss the case, and that was that this is not what's supposed to happen to SPEs in securitization structures. You senior creditors signed up for a particular set of rules to liquidate the collateral, to amend the indenture, and you're trying to circumvent those. And this would have a negative effect on expectations in the market. This is not fair pool, so to speak. And essentially the court focusing on that, I mean, I think everybody's always thought that the use of bankruptcy to try to unwind the expectations and the rules that were built in on the front end of a transaction, the use of bankruptcy to do that is just improper. And that's what the court said. And so it dismissed the case for cause on the grounds that, this is just not a proper use of bankruptcy. And the telltale sign of that was this was a brain-dead entity. It had no business. It was just holding self-liquidating assets like a typical SPE, right? I mean, there was no business to reorganize. There was no balance sheet where the debt needed to be converted to equity. There were no leases that needed to be rejected. There was no reorganization to be done. And that's what bankruptcy is really for. It's not suited for an SPE such as a CDO. And I think that really has a lot of ramifications well beyond that particular case.
But other than the technicalities of the case, right, we always say that SPVs are bankruptcy remote, not necessarily bankruptcy protected or
Proof.
proof.
Yeah, everybody wants to
So-
say they're proof.
Yeah, so does that mean that the case set a precedence for eliminating involuntary bankruptcy as a risk?
I certainly think it makes, well, let me back up. One thing that the structure of the Taberna CDO did not have was a waiver by participating creditors who invested in the structure of the right to be a petitioning creditor in connection with an involuntary petition. Why that wasn't there, I don't know, because that would have ended the inquiry. That would have killed this whole effort to use bankruptcy to circumvent the indenture, because they would have waived that right. A creditor has the absolute ability to waive and release its entire claim if it wants to. So a fortiori, it has the ability to waive a small component of that claim, which is the right to be one of the petitioning creditors in connection with an involuntary petition in bankruptcy. So that could have begun and ended the inquiry, but it didn't there. And so, I think, I'm not sure that in future structures, that element is going to be lacking. And so it may not be as much of an issue, but it's certainly, if there are any cases where the participating investors or creditors have not waived the right to be one of the petitioning creditors, then I think Taberna is a very good precedent for shutting down any attempt to use bankruptcy, an involuntary bankruptcy, to get what you couldn't get outside of bankruptcy.
But there are, Go
Yeah,
ahead.
if I could just ask, occasionally, I know over the years we've toyed with voluntary bankruptcies, just to restructure debt where you can't find
Sure.
all the bondholders. You ever seen that, or do you think that would work?
Well, it's funny, 'cause I think one of the things that comes to my mind in this is, oh, well, in the magical world of bankruptcy, that's exactly what you're supposed to do, right? Is blow up all the rules and change the indenture, and everything is supposed to be different. And I think what I like about the Taberna case is it says, yeah, when there is a reorganization purpose, when there is an intent to rehabilitate an ongoing business, all of that is fair game, but not with an SPE. Not with an entity that's just supposed to be brain dead, so to speak, and hold self-liquidating assets. You guys know all the truisms. But I mean, to say in that context that this just doesn't work is very helpful.
Okay, thank you. Next, we are going to talk about the ERISA fiduciary liability in our RMBS deals. So there was a Powell litigation that was brought on by an ERISA benefit pension plan, alleging violations of fiduciary duties under ERISA by the servicer and the master servicer of RMBS Trust. So Howard, can you tell us what happened there?
Sure.
I thought, they are supposed to be structured to avoid
Yeah,
ERISA fiduciary duties?
That's what I thought too. No, I think that, look, so far we've talked about legal rulings and appeals from legal rulings. I want to spend a few minutes talking about actually just a relatively recent complaint or legal action that was filed that is premised on the theory that Florence just described, which is at best a novel legal theory. I think unprecedented and erroneous probably is a better way to describe it. But in any event, I have a view. Really, the idea here is, and the idea behind the complaint is that the servicer and master servicer in this case of several RMBS trusts were transformed into ERISA fiduciaries when, unbeknownst to them, a ERISA pension plan invested in the RMBS trust at issue, bought notes and certificates. And how do we get here? How do plaintiffs make that claim? They make two sort of very basic premises. One is that the mortgages themselves, the underlying mortgages in the trusts, are plan assets. That is, they're assets of the pension plan, because by virtue of the pension plan investing in the trusts, the mortgages became assets of the plan. And I can get into that in a second. And then the second piece of the puzzle is they say, because the mortgages are assets of the pension plan, and because the servicer and master servicer has, quote unquote, discretion over the mortgages, the master servicer and servicer are all of a sudden ERISA fiduciaries. I don't think it works, but that's the theory. Did I mention I might have a view? But I think that, let me just talk for a minute about how they got there. There's, in ERISA, there's the plan assets rule. That is really, the general rule is that when a pension plan invests makes an investment, the investment itself may be a plan asset, but the underlying collateral is not. I mean, it makes sense, right? If a pension plan invests in IBM, the assets of IBM don't automatically become plan assets. But there is an exception to that rule, which is called a look-through exception. That is to say, if the plan's investment, pension plan's investment, is what is called is an equity interest as opposed to a debt vehicle, then it's possible that under certain circumstances the pension plan could, in fact, have a part and parcel with its investment plan assets. And plaintiffs are arguing in this case that the investment in their investment in certificates and notes of these transactions were in fact equity interests and not debt. And then separately, they are saying, of course, that the servicer and master servicer are acting with enough discretion over the plan assets to create this ERISA fiduciary liability. And you can see the issue here, right? I mean, this is serious, because if the plaintiff's theory holds any water, we could be looking at potential ERISA fiduciary liability for multiple deal parties of transactions where they don't even know that there are pension plans invested in the first instance. I mean, it seems a little silly and backwards, but that's where we are right now.
What was the nature of the security that the plan invested in?
Oh, it was, I mean, RMBS trust. I mean,
Okay.
there are notes, or there's several indentures where there are notes, and then
Okay.
there's PSA pass-through certificates where there are certificates.
Got it.
But these are not equity by definition, but that's certainly something we're arguing right now.
Is the case still ongoing?
Yes. So the parties filed a motion to dismiss and attached a bunch of evidence in connection with that motion to dismiss to the record, and the court then converted that motion to dismiss into a motion for summary judgment. And the parties will be filing motion for summary judgment in about a week and a half, March 6th.
And actually, step back for a minute. What was the reason that the pension plans filed this case
Well,
to begin with? Like, I just don't
Investment didn't do
understand.
so well.
Yeah, no, I mean, that's the thing. I don't know. I mean, I think I have my own skeptical view. There was some creative plaintiff lawyering here, but I think I view this as sort of the next step on RMBS legacy litigation. If this gets some traction, you could see a whole host of follow-on lawsuits.
But doesn't that just like stop the pension plan from investing in future RMBS deals in a way?
I don't think so. I mean, they're accusing, they're saying that the servicers and master servicers have some kind of ERISA fiduciary obligation.
Yeah, I mean, if I were structuring the trust, I would just say, it's not ERISA eligible
Oh, I'm sorry. You're
anymore.
asking going forward, can we restructure?
Yeah.
I'm sorry. I apologize.
Yeah.
I misunderstood the
No,
question.
that's
Did the
fine.
investor waive the
Right.
right to make this argument?
Well, arguably they have, but
Oh,
the
okay.
indenture has very clear restrictions on it. There's debt for tax opinions, first of all, that say these things are debt, and also in the indentures themselves, there is a statement that says these are debt instrument, that what you're purchasing is a debt instrument.
Yeah.
So, but
Aren't there like exhibits or certifications that they have to make in order to invest in them?
yes,
As an ERISA investor, that
Yes.
sort of goes with how the investment was disclosed in the first instance.
amen. Yes. No view at all. And I will say, speaking of no view, I will say that the SFA, I think, is in the process of filing an amicus brief in connection with this matter. And that's why, we'll look forward to seeing how it plays out.
Yeah, so we all look forward to that. I don't think there's any disagreement on the panel here. So next, we're going to move on to Valaway-Nate and the True-Lender cases. How many people here are not familiar with Madden versus Milland? All right, great. So, Mark, why don't you start?
Yes, thanks. Until June of 2019, well, I'll preface this by saying Madden was decided in 2015, and the Supreme Court denied cert, and so the ruling of the Second Circuit Court of Appeals in the Madden case still stands. Until June of 2019, aside from a couple of Colorado cases that I'll get to later, the primary impact of the Madden case has been limited to the Second Circuit states of New York, Connecticut, and Vermont. In those states, non-bank purchasers have avoided purchasing loans originated by banks in those jurisdictions with interest rates and fees that exceed the applicable state usury and fee limits. At least one academic study has concluded that the Madden decision had a chilling effect on the availability of consumer credit in the Second Circuit states. Now, fast forward to June of 2019, 2 putative class actions were filed against securitization affiliates of Chase and Capital One Bank in the Western and Eastern districts of New York by plaintiffs that are seeking to leverage off of the Second Circuit's decision in Madden. In those lawsuits, the plaintiffs are credit card customers of the banks, and they're claiming that various bank-affiliated securitization entities and their related trustees violated New York's civil usury statute by transferring credit card receivables to a securitization trust when many of the accounts had interest rates that exceeded the state's 16% usury limit. In the pleading, the plaintiffs have attempted to apply the Madden decision to argue that the securitization entities that purchase credit card receivables from national banks in connection with securitization transactions don't have the benefit of federal preemption that's held by the originating bank under the National Bank Act. If these lawsuits were to be successful, a wide range of securitized consumer debt products, including those backed by credit card receivables, auto loans, and personal loans, could become subject to state regulation in the states that sit within the Second Circuit, and they would likely have a chilling effect on origination volumes, and they'd restrict consumer access to credit in those states. But on a positive note for the industry, last month, a U.S. magistrate judge issued a report and recommendation to the court that recommended a rejection of the J.P. Morgan Chase class action. In that report, the magistrate concluded that the New York usury statutes are federally preempted for securitization entities that acquire credit card receivables from the originating bank in connection with the securitization transaction. In reaching the conclusion, the magistrate said the preemption question comes down to the question of whether applying New York's usury cap to those securitization entities would prevent or significantly interfere with the bank's ability to sell off or assign receivables on its credit card accounts. According to the magistrate's ruling, if the bank cannot pass along its right to collect interest as part of the transactions, then the banks can't fully assign its bundle of rights to the loans in connection with the sale and assignment to a non-bank securitization entity. Now, the plaintiff in this case has already filed a motion to challenge the findings in the magistrate's report as being in direct conflict with Madden, and at least 2 consumer groups have also filed amicus briefs objecting to the report's implication that national banks would be hamstrung if they can't assign loans or receivables to non-banks due to a lack of the federal preemption of state usury limitations.
So let me ask you this, Mark. I think in this case, right, you have a lot of the good facts because it's credit cards, the banks are still holding them on their book.
Right, the banks, in a credit card securitization, the banks actually just sell the receivables from the accounts, and they maintain the accounts, and they maintain the servicing of the accounts, and they have the continuing relationship with the card holders. So there is continued involvement with the banks in the receivables.
So, and what do you think would happen if those are not credit card receivables, for example? If they're like auto loans by a bank?
It probably depends on the structure of the transaction, but in most transactions that I've seen, the actual loans are sold into the securitization, not the receivables. So you'd need to do some restructuring if this were to be upheld.
If I could just ask, it sounds like that magistrate's reasoning, though, was not based on that. It was basically a front, more just taking Madden on, is that right?
Exactly.
Why would you do that?
It was basically a rejection of Madden.
Why wouldn't you make that argument?
Yeah.
All right, okay.
Of course you would.
I think that means, you know, it covers more than just credit cards. So to the securitization market is a great thing, but you have more room to challenge.
And this is just a magistrate's recommendation. This isn't the court's holding, so, you know, who knows what's going to happen. But
So can you talk about the proposed rules by the FDIC and the OCC?
Sure. The proposed rules, in November of last year, at the request of the industry and government officials and the Congress, each of the OCC and the FDIC issued proposed rules that would actually codify the valid when made doctrine that was rejected in Madden by providing that interest on a loan that is permissible under the National Bank Act will not be affected by the sale, assignment, or other transfer of the loan. And if these proposed rules are adopted substantially as proposed, they wouldn't overturn the Madden case, but they may reduce the likelihood of legal challenges to loan sales by banks to non-banks, both inside and outside the Second Circuit, to the extent that the courts are willing to give the agencies some deference.
Great. And let's move on to true lender, right? There are some cases in Colorado that are challenging the true lender of a bank partnership, especially for the fintech space.
Correct.
Can you?
Yeah,
us
I mean,
what
I guess,
happened?
you know, the question is whether the proposed Madden fix is going to have any impact on those
That's right.
cases. And the answer right now, if the proposed rules were adopted in their current form, they would not have an impact because really the bank fintech partnership models will continue to remain subject to the true lender challenges and enhanced regulatory scrutiny in jurisdictions such as Colorado, where the Avant and Marlette funding cases are pending.
Yeah, and with some background in the fintech space, the funding is usually done by a partnership bank, and they usually hold it for maybe a day or two before they're transferred either back to the lender. Well, you can't really call them lender, but the fintech
Yeah.
company, and then they warehouse them and securitize them.
That's correct. And the decision, or the argument that the Colorado administrator is making is that the finance companies or the fintech companies are actually the true lenders in their bank partnerships because they have the predominant economic interest in the loans that are originated by the banks.
And I think in these cases, the trusts themselves are named in the lawsuits.
That's correct. The administrator filed an amendment to the case to add several trusts and trustees as parties to the case.
So, yeah.
The defendants in the case have tried to remove the case to federal court, and the federal courts have kind of sent it back to the state court, saying that it's not a federal issue. The states need to handle it.
So, Eve, as our representative here from the trustee, what do you think about that?
Well, obviously, I don't think it's a good idea, but it's a tactic, right, that seems to be getting some speed. I think the issue for trustees is that in some cases you're named, like they were in the two Colorado cases, just by virtue of your role, having nothing to do with how you administer the transaction or any of your responsibilities. And I think because of the potential impact on the trust estate, the trustee obviously has an interest in what's going on in the litigation because of the ramifications of what that could mean for the trust. So I think the trustee sometimes is in the unique position because of how they hold an interest in the collateral of being embroiled in these litigations. And, you know, fortunately, if you have other entities who sponsor the deal who will actively manage the litigation, you're just involved in terms of making sure that you understand how it impacts the securitization and any responsibilities you might have based on the consequences of the litigation.
So even though the sponsors are defending the trusts, are there any liabilities to the trustees?
Well, sure, yeah. So if there's any assignee liability, right, it belongs to the trust. The trustee is entitled to those indemnification rights, but certainly there's reputation risk for the trustee. And the trustee is nominally named, so obviously you don't have really very passive involvement. You have a real interest in what's going on in the case.
I would just mention or add to that, heard through the grapevine that some fintech companies are asking their trustees to hold legal title to the assets that are transferred into the trusts, just to avoid the Madden preemption issue, because the assets with legal title would then be held by a national bank, which has the benefit of federal preemption. So any thoughts on that?
I think that that's been going on for some time. I think, you know, trustees look at the nature of the assets, the nature of their roles, whether the indemnification is adequate. Certainly, I don't think that we view ourselves as providing that kind of protection for investors. I mean, to us, if it's in our name, it's to facilitate a role in the transaction, and we need to be adequately protected.
So next, moving on to LIBOR. I think we had some LIBOR panels earlier in this conference, but they're not focused on the legal implications of a LIBOR transition event. So Howard, can you tell us about what kind of litigation issues we should be expecting?
Sure. Thank you. Yes. Look, I think there's probably, you know, after sort of the several panels we've had on LIBOR already, people are maybe sick of hearing about LIBOR, but I think that there's probably truisms I can say. LIBOR is going away at some point, and there will be litigation in connection with that because of the inherent value transfer associated with the LIBOR transition. I think there's many flavors of the potential litigation claims. There could be contractual related claims, especially with connection with legacy transactions, where there's limited fallback language, no fallback language, or there's a dispute, of course, over how the fallback language should operate. That could be at the securitization level, and then there's also at the collateral level as well in terms of the various assets. You know, I think that the minute a potential borrower, right, of a mortgage loan has his or her rate go up, you could see it could be a recipe for various mischief makers to create some issues. So you have that piece. Then you have we refer to as the implementation-related claims. That is to say, even if the parties to a transaction can agree on how this is going to work, how that actually, how the rate, the new rate is implemented, and how those proceeds are distributed to investors, there could be issues with that because there could be different views on how that process will work. And then, lastly, I think it's maybe the most interesting of this. There's the constitutional law aspect of this, based on potential legislation, right? And so, I don't know, Chris, do you want to?
Sure. One of the proposals that came out of the ARC, and it was in there, you can actually look it up on the ARC website on the November 15th, 2019 meeting, was the idea of a legislative solution in New York to LIBOR. And it was basically going to be, it was going to be a statute that would do a couple of things. It would apply to contracts that are just silent, like if your contract just says these bonds are payable in LIBOR and doesn't say anything more, it would apply to that contract. It would apply to contracts that have fallback language that is specific to LIBOR, meaning basically last quoted LIBOR or other interbank lending rates, and would not affect contracts that had a different type of fallback, for example, the prime rate. So one of the first questions that comes up if you're actually going to propose a legislation like this, which I assume is in large part geared to keep a lot of cases out of the New York court. So it's sort of it's sort of the reverse way of looking at litigation. Is this constitutional? Does this violate the impairments clause of the federal Constitution? And I think, and the other one could be possible takings. And like everything in constitutional law, it's kind of murky, and it's not a whole lot of guidance. I guess this thing has the benefit, such a statute would have the benefit that it's not obvious that it favors any particular party, right? Although, as was said, somebody probably will end up being favored,
right?
But it doesn't come at it from that angle. It also is not a lot of the cases where they do strike down, where they're takings or they strike something down, is the state is actually involved as a party, and one does not have that here. This is contracts between private parties. I would think, Eve, it certainly would be. I'll get to something else in a minute, but it sounds like it would be helpful to trustees to have such a statute. Is that fair to say? Because otherwise, one of the things it's trying to head off is the need to solicit bondholder consent.
So it's not a panacea. I think it's helpful. I think everybody would be supportive of having greater certainty as to what is a comparable rate, and other kinds of things where you have a role in making that decision. And sometimes that may be the trustees, sometimes that may be other deal parties. I think what is challenging about navigating sort of the LIBOR transition now is there are so many things that are unknown. And so everybody is sort of preparing for multiple scenarios that may transpire. And so legislation in terms of sort of legally in New York, for example, what is comparable, or if you follow a process that you would be protected by some kind of safe harbor, gives people a bit of comfort in terms of how they navigate it. But, there's other jurisdictions that are applicable. New York is not the only jurisdiction, and if you're talking about consumer assets, you're talking about all 50 states.
Yeah, in a lot of consumer assets, it is given over to, like in mortgages, in the Fannie Freddie note, it's given over to the lender to basically choose it. The
Whoever the
replacement,
lender is, yeah.
The holder.
So just a question, Eve, to your comment about the 50 states, right? I thought the safe harbor was meant to apply to the trusts that are under
Yeah, so you're
the New York
talking about
law.
at the security level, but there's some risk associated with the replacement rate at the underlying collateral level. And so that is tied to the consumer. And so that would not necessarily be governed by New York, just simply because you have an indenture or a pooling and servicing agreement that's governed under New York law. There's also plenty of transactions where you have a debt structure and you have an SPV, as we've talked about, that are subject to Delaware law. So that's a different jurisdiction than New York as well.
I think the thinking would be that it would try to turn this into a model law at some point if it actually were to happen.
Oh, that'd be great.
Let me mention one fly in the ointment of this, though, doesn't come up so much in structured financial law, it comes up in some deals, is the Trust Indenture Act because the New York legislation obviously can deal with state contract law matters, but it cannot supersede federal law, and the Trust Indenture Act, generally, could easily be read to require unanimous bondholder consent to do any of these things. So that sort of is hanging out there.
That's a good point. I mean, I think it's interesting because the legislation is sort of designed to provide some level of comfort, as he points out, and some level of certainty to what's going to happen. But I think if there are challenges, right, to the legislation, that creates another level of uncertainty because people don't know whether to actually follow the legislation or wait till the resolution of court challenges. And then, of course, you talk about timing. LIBOR is going to go away at the end of 2021, and do you sort of guess that the legislation is going to survive, or do you have to sort of make alternative plans to deal with if the legislation is overturned? So I think it's an issue not only of just sort of figuring out the right legislation, but it's also it's making sure that if it's passed, that people are actually going to be able to follow it with some level of certainty.
And how likely is it that we'll be able to get legislation passed in the
Right.
current Congress?
Right.
So,
Unknown at this point. There was the case I found the closest to this, and you're right, it could be challenged, just like I was talking earlier about the private parties, bringing these issues up. There was a case from 1935, a Supreme Court case. I guess this was a point in time, it was during the Depression, when contracts sometimes were written to be settled in gold. And Congress, as a matter of public policy, says, nope, any contract that can be settled in gold can also be settled in paper money. And this goes up to the Supreme Court. And that was held to be okay, that you could do that. So it seems like the closest thing to this. You also have, by the way, in New York State, the New York State Constitution, which does not have an impairments clause, but does have a takings clause. So it'll provide, if it does go through, to answer your question, if it comes up in New York, it provides a whole nother arena for lobbying on LIBOR. Besides ARC, now you've got to lobby the New York State Legislature and the Governor's Office and the Department of Financial Services and the Attorney General's Office and so on and so forth.
That's right. I think one other potential constitutional challenge that you could think about in terms of LIBOR is the anti-delegation clause of the Constitution, and I think that's an interesting issue, and it's not something that I ever considered. I give credit to my partner Jason Juergens for this, but the idea is that if in fact the New York legislature is saying that is delegating to a private party, in essence ARC, the ability to sort of create the new rate or create a new environment for a rate, then that could violate the anti-delegation clause. And I think that's an interesting legal issue.
That's a good one. I like that. Yep. We'll add that to the list. Yep.
And so with that, I'm going to open the floor for questions.
Hi, this is not so much of a court question, but in terms of California, AB 539 playing out with all the Madden stuff and Colorado stuff, I just wanted to know what people's thoughts were.
I'm not familiar with that, so.
Yeah, I'm not familiar with the, I know generally what the California legislature is trying to do. I'm not sure if it's actually been passed yet. Any California lawyers out there?
Yeah. Is there anything more specific that you would like to ask our panelists?
So AB 539 was passed in California, I think on January 1st.
Okay.
Pretty much saying, non-bank lenders can't lend above 36%. So how do you think that will play out, particularly with the bank sponsor model, or even I know US Bank has a above 36% product, small dollar type lending?
I mean, clearly that can have a chilling impact on originations in California, I would think, for the payday lenders in particular, and maybe for the fintechs, depending on their interest rate of their products. So.
Should the proposed rules separate the two, do you think? The fintech space versus the payday lending space?
If the yes, if the California courts would give deference to the proposals and they're implemented, that could prove helpful. So.
Any other questions?
In light of the LIBOR fixing scandal and how that came about from banks informally quoting LIBOR to their friends, when we go to a series of fallbacks where there's a dial rate for LIBOR, is there any thought of panel banks in advance of that making a statement that no employee will be authorized to quote LIBOR, just to make it very clear that, any given trustee or servicer, is not ever going to be charged with calling the wrong person at the wrong bank or not taking a representative sample when it becomes very clear that no one will quote this? Because I haven't heard that, but that would probably be helpful in just preventing some of the nonsense that we may see.
It's interesting, right? I think that's certainly something that could happen. I think the reality is, though, when you have a situation where a contract directs you to do certain things, just because a bank has said that they're not going to respond to your question doesn't necessarily relieve you of the burden to follow that condition precedent. I'm sure there's arguments on both sides. You could argue that it's futile because of the bank's statements, but are there other banks that are available to what is a major bank in New York or London? So I think it's interesting, but I don't know in reality how that works.
But I would think why ARC picked SOFR as the replacement benchmark is because it's more transparent than LIBOR.
Yeah, but I think the ARC working group, in particular, I think the DATE group is focused on some of this polling of banks and making recommendations up through the governance that may provide sort of more certainty as to how people would implement the polling process. But I don't think banks giving direction to their employees and not picking up the phone, as Howard has indicated, excuses contractual performance necessarily.
Arguably, at least.
Yes.
One last question?
Hi. Okay. You mentioned that in some instances now, the banks as trustees are being asked to hold legal title to the assets of the securitization. I've heard it repeated many times that people already consider the fact that the securitization has a national bank as a trustee as insulating the securitization from any kind of national bank preemption type assaults. So the fact that somebody's coming out and asking the bank to hold the assets directly, do you think that the fact that that's being proposed is some way an implicit maybe you're refuting the existing position that some people are taking?
It's true for a common law trust that the trustee has title to the assets. For a Delaware statutory trust, I think it can be either way, and then you can elect to have the trustee hold legal title to the assets. So I think that's what really they're talking about, is having, in the context of a Delaware statutory trust, that the trustee actually take the legal title in order to ensure the benefit of the federal preemption, or to at least bolster the case for that. Again, it remains.
It hasn't traditionally done it.
Correct. Not in my experience. So, Chris, do you have any different?
No, same.
Okay. Great. So with that, we conclude our panel. Thank you so much for